As you are entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually and, unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's September 26, 2025 free CLE webinar, Importance of Proper Service of Process. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. The chat feature is disabled. Some of the questions will be answered by the presenter throughout the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. We are not taking attendance. I will now turn it over to the FRP Enrichment Committee CLE Subcommittee member, Jennifer Baker.
Thank you, Diana. The Florida Registered Paralegal Enrichment Committee invites all of our participants today to visit the FRP Corner on the Florida Bar website, as well as our various social media platforms. It is there that you will find helpful tips and announcements of upcoming events and our monthly webinars. Kevin Fedotov began his career in the service of process profession in 2012 with the launch of the Ninth Circuit Process Server program. He currently works with LegalServe USA in the Skip, Trace, and Affidavit of Diligence Search Department, and on occasion still delivers bad news. He has served multiple consecutive terms on the board of the Florida Association of Professional Process Servers, FAPS, and also co-chairs the FAPS Education and Promotion and Growth Committees, where he is dedicated to advancing professionalism and public awareness in the field. Thank you, Kevin, for presenting today. I will now turn it over to you.
Thanks, Jennifer. Can you guys hear me okay?
Yes, we can.
Perfect. Yeah, so welcome. Happy Finally Friday, everyone. Bear with me. I came down with a bit of a cold a couple of days ago, so my throat's a little itchy. I might be muting myself here and there to cough or sneeze. Please find it in your heart to forgive me in advance if that happens. But we're here to talk about the importance of service of process. My goal here is to teach you something new. I think I'm in a good position to do that because not only am I someone who runs a small process serving business, I'm also someone that still delivers legal documents on a daily basis. My goal here, since we don't have a whole lot of time, is not to teach you how to serve process, because I teach a 16-hour class, so you can sign up for one of those any day. We're only going to cover the information that relates to real life and day-to-day stuff. I've taken some excerpts of the most common type of documents we deal with as a process server and as a business owner and condensed them into a summary that you, as the paralegal, so that you can understand the affidavit of service that you receive from us at the end of the day. Being able to read these proofs of service ensures that service was completed correctly and in accordance with one of the Florida Chapter 48 statutes, which we will discuss shortly. This will prevent future issues with your case, such as motions to quash, being unable to collect on judgments, evict the tenant, or even proceed with your case. So with that being said, every service is deemed valid until it's not, right? We're going to take a look at some examples of service. I can tell you guys, provide a proof of service for you, but if the information in it is incorrect and you file that affidavit, the opposing party may file a motion to quash service. So it's very important. I'm going to run through these very quickly because Jennifer already mentioned, as she said, I'm from Ukraine. I came to America in 1999. I've lived in Florida my entire life. I got married this year, got a baby on the way. And whenever I'm not serving process or making my wife happy, I am out with my family fishing. That's me and my dad, Alex, who also runs the Legal Serve USA business with me. We're a small family business, and yeah, we like to keep it that way. This is my third process serving business, and I think third time's the charm. So just a couple career highlights. I went to college in Florida Southern, got my undergrad in business, got my master's in business. I did not intend to be a process server. Had a terrible accident, almost broke my back and couldn't walk for about 6 months. So I knew I needed to find a different career change after I kept getting laid off in the health insurance world. So in 2012, the Ninth Circuit program in Orange County opened up for licensing. I was able to obtain my license and I started serving process back in 2012. So I've been doing this for quite a while. As Jennifer mentioned, I'm very involved in the Florida Association of Professional Process Servers. Think of this as the Florida bar for process servers. They provide tons of education, legislation, and other things that that process servers deal with. Also, those are you guys, if you're ever looking for a process server, you can go to this website. I've got the link down at the bottom. It's faps.org, and there's a link to find process servers on there. All of the process servers that are on this list have taken the course and completed the requirements. So if you're looking at this list, you're dealing with solid people. History of service of process has its roots dating back to the Magna Carta, which was created in 1215. And most notably, our roots come from the right to due process, right? Most notably, the right to a fair trial. So what governs service of process nowadays? We deal with Chapter 48. I'm not going to bore you with the entire chapter. I've highlighted some specific sections that we deal with on a day-to-day basis and that you as the paralegal most likely deal with as well. So these chapters are constantly being rewritten, things are added and taken away. But back in the day, the sheriff used to ride around on a horse and deliver some bad news to you, and then he would take a piece of your the collar of your shirt off and bring it back to the king as proof of service. Nowadays, with the adoption of Chapter 48 and all the new technology, we create electronic affidavits of service and returns of service and provide these to you guys almost instantaneously after service has been completed. So let's get into Chapter 48. Process and how directed. Summons, subpoenas, and other process and civil actions run throughout the state. This means that I serve someone in Orange County in the same exact manner as someone else would serve them in Palm Beach or Flagler or Volusia. Process runs throughout the state. Who can serve this process? At 48.021 says all process shall be served by the sheriff, but we know that the sheriff doesn't like to typically serve civil process, except non-enforceable civil process, including criminal witness subpoenas and criminal summons, may be served by a special process server appointed by the sheriff or by a certified process server. So we've got 4 types of process servers in the state of Florida. Your most basic one is the local sheriff. These guys generally serve criminal stuff, right? They don't want to be out there dealing with medical record subpoenas and divorce papers. Then you've got your certified process servers. Every county in the state of Florida, there are 67 counties, and each county can choose what type of program they want to have. They can have a certified process server program like we have in the Ninth Circuit for Orange, Osceola counties, or like the special process server program, which is done by the sheriff. And for example, in Pinellas County, the sheriff, they chose to have a sheriff appointed program. So the sheriff is in charge of that. Us certified process servers, we can only serve process in that circuit. So me being a process server in the Ninth Circuit doesn't mean I can get in the car and drive down to Miami or anywhere else outside of those 2 counties to serve the process. Your special process servers like the Pinellas County Sheriffs, the ones appointed by the Pinellas County Sheriff, those guys can only serve in the county where the sheriff resides. So only in Pinellas County for those people. And then you have counties where there are no private process servers. Some of you guys may have dealt with. This is the motion and order. There are no licensed process servers in that area because there is no education program or program established by the courts So on each case where you need to serve something like a summons or a criminal witness subpoena, you have to do a motion and order to appoint process server. Now, why are these important? Because the education requirements for all these process servers is different. In the circuit program, a brand new process server has to take a 16-hour course before they can apply for licensing. The renewing process server, because you have to renew your license annually, takes a 4-hour class. Those who are appointed by the sheriff, their education program varies on a county by county basis. Some of them have multi-day courses, some of them don't have a course at all, and all they do is come in and take a test. And those without an education program, obviously there's no education requirement. So it's very important that you guys are working with process servers who know Chapter 48 and how to serve process. Here's a quick overview of the Florida process appointment by county. As you guys can see, there are 67 counties in Florida. Some of these counties are done by motion and order, some are appointed by the sheriff, and some are a circuit program. It is not, because you guys aren't the process server, it's not very important for you guys to know this unless you're working with individual process servers in this area. But the process serving company you work with should know that whenever you send a summons to a county like Volusia, you need to do something called a motion and order. Now, nationwide, there's all sorts of different kinds of process servers. I'm an expert in Florida process. I'm not 100% sure what every single other state requires, because we serve process in accordance of the rule where the papers originate. So nationwide, you've got all sorts of process servers. You've got your circuits, your sheriffs, you've got your motion and order, and in some areas, you have something what I call 18 living and breathing. These are the guys who are, as long as they're a resident of the state they're in, I believe some areas of Georgia still allow for this. Not going to name the other states, but these states, they don't have any program whatsoever. So anyone who's a resident of that state can technically serve process. So again, it's not your job to know what these states are, and I'll show you guys the full list in just a moment, but it's very important that the process serving company you work with know that when you're sending legal documents to another state, they have to have someone who's authorized or licensed, right? Because in accordance with 48.194, personal service in another state, territory, or Commonwealth of the United States, service must be made by any person authorized to serve process in the state where service shall be made. And in that instance, no order of court is required. Florida does not consider process servers who are 18 living and breathing as quote unquote authorized process servers. So I'll mention to you guys, and I'll send the presentation so you have a copy of these statutes and lists of states in case you guys are sending process nationwide or to areas in a motion and order county. But process in accordance with Florida laws is not permitted in Alaska, Arkansas, Connecticut, Delaware, Georgia, Hawaii, Kansas, Kentucky, Louisiana, Maine, Massachusetts, Missouri, Nebraska, North Carolina, Ohio, Oklahoma, Pennsylvania, except in Philly County, South Dakota, Tennessee, Vermont, and Virginia. If you guys are sending summons or criminal witness subpoenas to those states, you have to do a motion and order to appoint process server. Otherwise, service may be challenged. And as I had in my second slide, all service is deemed valid until it's not. There you go. They'll send you an affidavit of service, but they may not be authorized under Florida laws. So it's very important you guys understand this. Return of execution. This is what we provide to you guys and gals once we complete the service. So Florida Statute 48.21 subsection 1 states that each person who effects service of process shall note on the return of service form attached the date and time when it comes to hand, the process service hand, the date and time when it is served, the manner of service, the name of the person on whom it was served, and if the person was served in a representative capacity, their position. Okay, the return of service form must list all the pleadings and documents served and be signed by the person who effects service of process. All of those things are required to be on the return of service. Otherwise, it can be challenged just because there's lack of information. A failure to state the facts as written in subsection 2 or to include the signature as required invalidates the service, but you can always amend the return to state the facts or to include the signature at any time on application to the court from which it is issued. So if you make a mistake, you can always amend that return to service. Just real quick, wanted to talk about affidavits, returns of service, proofs of service. In general, anytime we provide to you the document that states the manner of service, it's the blanket term is called a proof of service. These proofs of service come in two flavors. The first one is the affidavit of service, and the second one is the return of service. The only difference between these two is that the affidavit is notarized. Why would it be notarized? Because in certain areas, such as in counties and states where you are required to do a motion in order to appoint the process server, those guys have to have their returns of service notarized. Us who are licensed by the circuit or sheriff, typically an electronic signature is acceptable. But that's the only difference between an affidavit and a return. They have the same exact information, except the affidavit is notarized. Now, here's how to serve someone. This is 48.031. This is the most important statute when it comes to service of process. Every process server should have this burnt in the back of their heads. So subsection 1A says, service of original process is made by delivering a copy of it to the person to be served with a copy of the complaint, petition, or other pleading or paper. This is telling us that I can serve an individual, and again, 48.031 talks about service on an individual, not an entity such as a company. We'll get to those later. But service of process on an individual can be made anywhere where we can find that individual. So I can serve Diana at home, in her car, at her place of employment, on the way to the grocery store, wherever I can find her, and wherever I am licensed to serve her. Second part of this says, or by leaving copies of it at his or her usual place of abode with any person residing therein who is at least 15 years of age or older, and informing the person of their contents. So if I'm serving Diana and I go to her house and she's not home, if I meet the 4 requirements, right, and we have to look at these like a checklist, because if we do not complete all aspects of the checklist, service may be quashed. So the person I'm leaving the documents with has to live there. Diana has to live there. That person I'm leaving the documents with has to be 15 years of age or older. And I have to inform them of the contents, meaning I have to say, hey, Mr. Diana's co-resident, I'm Kevin, process server. I'm delivering the legal documents to Diana. It looks like Bank of America has taken her to court. Court date is September 30th, et cetera, et cetera. But you do have to inform the person of the contents. And it's very important you do, because there's case law in Johnston versus Halliday where the return of service was defective because the things weren't met in this checklist. If you guys ever want to take a look at this case law, this is probably one of the worst ones, because the process server didn't do any of the 4 requirements. He substitute served a boy who was under the age of 15. The boy didn't live there, and he didn't inform him of the contents. So having not met a single one of those, service would have been quashed. And I just want to take a quick break to take a look at some questions here. I see for Florida service that will be taking place in another state, such as Georgia, that needs a motion in order. Is that for all types of documents being served, summons versus subpoena, and all courts? Excellent question. So the long answer is the motion in order is only required for state court summons and criminal witness subpoenas and summons. It's not required for civil subpoenas, and it's not required for federal documents, whether it be a federal summons or a federal subpoena. You do not need to do the motion in order appointment. Got another question. What is required of the process server to verify that the person served is the correct person? So generally, process serving involves a little bit of a communication. When we go knock on the door, we obviously have to ask for that person. Every paper we serve at a residence on an individual is different. If you guys aren't providing photos to your process server, well, it kind of makes it difficult for them to be able to identify them if they're going to avoid service. We do have tools we use, nowadays with social media and LinkedIn and, property appraiser. We have tools that we can use to verify that the defendant lives there. But unless you provide a photo, it's going to be very difficult. All right, so that's Johnston versus Halliday. I'm not signing for anything, or I don't want it, is what I hear more often than anything. Florida statute 48.031 subsection 5 says a person serving process shall place on the first page only of at least one of the processes served the date and time of service, their initials, and ID number. As long as a process server puts those 4 things on the document, they can leave it at their feet. We'll look at some case law about that later, but there's nothing in the statutes that says if I'm serving Diana that I have to hand the documents to Diana and that she has to physically accept them or she has to sign for them. There's nothing in the Florida statutes that talks about that. So whenever your guys' process server is saying, hey, he doesn't want it or he's not willing to take it, well, that's when you just leave it at their feet, as long as you've identified that person. And here's the case law that talks about endorsing writs. And Scott versus Newkirk, someone tried to quash service because the process server only endorsed the summons and not the complaint and exhibits and notice of lis pendens and everything else. Courts ruled that the Florida statutes only required that the information to appear on the copy of the summons or subpoena or whatever type of document you're serving, be it a writ or an eviction summons. So we learned how to serve an individual anywhere where we can find them, and we learned how to serve someone at a residence via a co-resident. So who else can be served? Well, subsection 2A talks about substitute service on the spouse of the person to be served may be made at any place in the county by an authorized individual if you meet the certain criteria. In bold, it says if the cause of action is not an adversarial proceeding, if the spouse requests such service or the spouse is also a party to the action, and if the spouse and the person to be served reside together in the same dwelling, you can substitute serve a spouse away from the residence. So if I'm serving Diana, the only person away from the house I can serve is her spouse. These are, I combine these into one. We don't deal with them too often, but service on a minor and service on an incompetent. And this is someone who's been declared legally incompetent. Typically, they have their guardian, and all the statutes say you can serve the parent or guardian in accordance with 48.031. So if we're serving the parent or guardian in accordance with 48.031 at their house, we can substitute serve any co-resident to that parent or guardian. And down here at the bottom, service on a state prisoner. This one's my favorite to remember. It's so easy. Service on a state prisoner shall be served on the prisoner. Nowadays, there's an attack on traditional in-hand service of process by all sorts of entities. But some sheriffs and some jails are making up rules that, they're now taking the documents from the process server and going inside the jail and handing it to them. That's not valid service. Right? 48.051 says service on a prisoner shall be made on the prisoner. No ifs, ands, or buts. That prisoner must be served individually. Here's something else I hear all the time. So the attorney said, just post it, right? If they're not opening the door, just post it. There are only certain types of documents that allow you to statutorily post them. Okay, these are the criminal witness subpoenas, your landlord eviction summons, the 5-day eviction summons on named parties and unknown parties in possession, and your landlord tenant notices and demand letters. So let's talk about the criminal witness subpoena first. A criminal witness subpoena commanding the witness to appear for a court appearance may be posted by a person authorized to serve process at the witness's residence if 3 attempts to serve the subpoena made at different times of the day or night have failed. Okay, so criminal witness subpoenas generally come in 2 flavors. You've got your court appearance, which could be something like a hearing, trial, pretrial conference. And then you've got your criminal witness subpoena for a deposition. The deposition says it may be posted by a person authorized to serve process at their residence if one attempt to serve the subpoena has failed. But again, at their residence, right? How do we know they live there? We need some type of verification. Now let's talk about service of process in action for possession of premises. And guys, I do see your questions flying in. I'm going to do my best, because I see a lot of them, to kind of wrap it up with plenty of time to ask questions, okay? Service of process in action for possession of premises. So those of you guys who practice landlord-tenant law or work with the attorneys who do the evictions, this is what must happen. In an action for possession of any residential premises, if the tenant cannot be found, or there's no one 15 years of age or older residing at the tenant's usual place of abode in that county, the summons may be served by attaching a copy to a conspicuous place on the property in the complaint or summons. The minimum time delay between these two attempts to obtain service will be 6 hours. Okay. If a landlord causes or anticipates causing a defendant to be served with a summons and complaint solely by attaching them to some conspicuous place on the property, the landlord shall provide the clerk with the additional copy of the complaint in a pre-stamped envelope addressed to the defendant. So the 5-day eviction summons, it's one of these unique documents that we can post to the door after we meet the two attempts 6 hours apart. Those of you guys who are in landlord-tenant law, and I see this all the time, take a look at those affidavits. What I started noticing is that some people are saying they received the documents at something like noon today. They attempted service at noon, 5 minutes later after they received them, and they returned exactly at 6:05 p.m. to post the documents. Please make sure you don't have one of those who are putting in fake attempts. Process servers have been getting in trouble nowadays with the Ring doorbell cameras and the, all sorts of technology that they're not making the statutorily required attempts. Service may be quashed, and you will have to start all over. This is a newer statute. This one came in, I believe, in the beginning of 2023. This is service of process for removal of unknown parties or parties in possession. Sometimes there's people living at the house and the landlord may not know their names, be it a squatter or, boyfriend, girlfriend, whatever the situation is, the landlord does not know what the name of there is. So they have a summons for unknown party in possession. These folks have a different statute in how to complete their service. So subsection 3.8 says if service on the unknown occupant or occupants is not effectuated on the first attempt, at least 2 additional attempts must be made. These 3 attempts to obtain service must be made once on the weekend, once during business hours, once during non-business hours, and once on a weekend. And as we'll see later, there is no service of process in Florida on Sundays. So that weekend has to be a Saturday. The statute also says service of process must also be made on the unknown occupants by both of the following means: by attaching a copy of the summons and complaint to a conspicuous location involved in the proceeding. So not only do you have to serve the unknown tenant, you also have to have an extra copy to tape it to the door, because as subsection 5 says, service is effective on the unknown occupant or occupants in possession on the later of the date that personal service is made, the date of attaching the summons and complaint to a conspicuous location on the premises, or upon mailing by the clerk. And thank you, Karen, for reminding me. It's very important that if the documents are posted, the clerk also mails a copy of them, because if I post them today, but you don't do the mailing until 2 weeks later, well, that service isn't valid until 2 weeks later. All right, so that's it for individuals. That's how you serve people. We talked about how to serve people anywhere we can find them, at the residence and away from the residence. Now we're going to talk about serving entities, such as partnerships, corporations, limited liability companies. They come in all sorts of different flavors: domestic, foreign, limited liability, limited partnerships. But if they register to do business in the state of Florida, in accordance with 48.091, they must designate a registered agent and registered office in accordance with Chapter 605. So every domestic limited liability partnership and corporation and company, all those entities that elect to designate that registered agent shall cause the designated registered agent to keep the designated registered office open from at least 10 a.m. to 12 p.m. Monday through Friday, excluding Saturdays, Sundays, and legal holidays. Starting October 1st, the new statute goes into effect, and that registered agent has to be there not only from 10 to 12, but also from 2 to 4 p.m. And there's been some other modifications to the statute to make it, to make it easier for the registered agent to designate someone in their place to accept service. Because we know, typically the registered agent may be an attorney and they're probably out of the office. Here's that 4.8. A registered agent who is a natural person may be served with process in accordance with 48.031. We talked about that one in the beginning. That's where I can serve the registered agent at the house, individually, or anywhere I can find them, or a co-resident or spouse. If such natural person is not present at the designated registered office at the time of service, made to serve the process, including during the first attempt on any employee of such natural person who is present at the designated registered office at the time. So that's the clarification. If the registered agent's not there, we can serve it to any employee of the registered agent. So whenever we're serving any type of entity or partnership, LLC, corporation, we typically serve the registered agent first. If the registered agent is not available, then we branch off into our different type of corporate hierarchy, right? So we've got the first one here is a limited liability company. These are the LLC. 48.062 says you can serve on the registered agent designated, or if service cannot be made on the registered agent, you can serve any manager of the manager managed LLC, on any member, if it's a member managed LLC, or on any person listed publicly on that annual report. Okay, so LLCs are a bit tough to serve because the statute says either the registered agent in accordance with 48.031, or on the manager or member, or anyone else listed on the annual report. So these LLCs, they're typically the one-man operation, so they don't have that big corporate hierarchy for us to go down the list and try to find them. Service on a domestic corporation. This is our Incs, right? So first part of it says, may be served with process required or authorized by law on the registered agent. If the registered agent's not available, we go down that corporation's hierarchy. We start with the chair of the board of directors, the president, vice president, secretary, treasurer, or anyone else listed on that annual report. Okay, so a bit different than the limited liability company. I get asked all the time, how do I serve a company that is no longer active? And that's one of the slides I forgot to put in here. So to serve an inactive corporation or LLC that was dissolved after July 1st, 1990, so after July 1st, 1990, which is going to be most of them, you would serve it just like you would serve an active corporation. Okay, so if it's no longer active, you're still going to want to make your way down that corporate hierarchy. Service on a financial institution. This is for you guys that deal with the writs of garnishments, right? So if you're trying to serve a bank, the statute says a financial institution authorized by federal or state law to transact business in this state may designate with the Department of State or place a registered agent located within the state as the financial institution's sole location or agent for service of process. So the example I want to give on this next slide, if you're serving a writ of garnishment on Bank of America, I would highly recommend whenever you serve these writs of garnishments to go on the Sunbiz webpage and look up the entity. If they have a registered agent designated, that is the sole location for all service process. Now, 3A says, If a financial institution has no registered agent or service cannot be made in accordance with the subsection, let's say CT Corp burned down, or for some reason they stopped taking service, service may be made to any officer, director, or business agent of the financial institution at its principal place of business or at any other branch, office, or place of business in this state. All right, service by other means. This one is also new as of 2023. If after due diligence, and you're trying to serve some of these entities, sometimes electronic service is now permissible. Typically, these require an affidavit of diligence search, but the court may authorize other methods of service consistent with principles of due process. I've seen folks get served by Facebook, by email, but they're always typically complying with some sort of statute, be it attempting in-hand service at every known address, and then completing that affidavit of diligence search. Because remember, the judges are going to want to see that you attempted in-hand service. So what can't we do? We can't lie. We can't lie to people. We can't dress up or conceal our identity. People say, Kevin, can you dress up as a flower delivery guy and bring flowers to the wife? We cannot do that. All right. We can't mislead defendants into accepting service. Kevin, can you coordinate service and, tell the person that they're coming to do an estimate at your house, but you're really going to serve them? We're not allowed to do that. We cannot mislead people into doing that. Trespass, believe it or not, there is no immunity for process servers against trespassing. So whenever I go to that door and I'm knocking on that door, I'm not trespassing. I'm there in my capacity as a process server delivering legal documents. But as soon as that person tells me to get off their property, technically I have to leave, right? Hopefully I've completed service and identified that person, but I have to leave if they tell me to get off their property. Looking inside the house, taking photos, you never know what's in there. That's, people have right to privacy, and someone's home, the inside of the home is definitely an invasion of privacy. We're not allowed to touch mailboxes, so we can't look inside of them, take anything out of them, put anything inside of them. We're not allowed to just post any document unless there's a specific statute providing you with guidance on how to post that document. Ring doorbell service. I get this one all the time. I'm at the house, no one's home, they have a doorbell and they say, hey, Kevin, I'm not home, but you can leave it at the door, right? Or the attorney says they're not answering, no one's home, just leave it at the door. There is no statute that we've gone over today that talks about ring doorbell service because there is none. I have to serve the paperwork in accordance with Chapter 48. Until there's a provision to just leave it there, I can't leave it there. And we cannot serve on Sundays, service of process on Sundays, service of execution of any writ, process, warrant, order, or judgment is void, and any officer furnished with is void, and the person serving or executing it is liable for damages. So if you guys are working with out-of-state process serving companies directly, some states allow for service on Sundays, California, for example. If you guys are working with those process servers directly, make sure they know not to serve your Florida process on Sunday, okay? It can be done. In my 13 years of service, I have never once served anyone on Sunday. It can be done with a special order from the trial court judge. There's some people out there that intend to escape, on Sunday because they know they cannot be served. So the judge will issue an order for service of process on Sunday. This typically happens, the only examples I've seen it with our other educator, he said he served someone with an order on a cruise ship because, they come to port on Sunday, or he served the NFL player in Miami on the NFL Sunday. There was a football game, so he was able to serve him on Sunday. Quick message from the Florida Association of Professional Process Service in regards to electronic and portal service. You guys might have seen places like Bank of America and CT Corp set up these portals where you can upload the documents and quote unquote serve it yourself. Please don't be fooled. We haven't learned there is no statute or provision that allows for service of process via portal or electronic submission until, all service is valid until it's quashed. So, they may provide the records or they may proceed with the case, but if someone decides to challenge the service, you do not have a proper affidavit of service that outlines how you served that paper in accordance with what statute. Remember, there is no method of service outside of what is outlined in the Florida statutes. For example, the creation of the new method of development of receipt of an entity like CT Corp does not override Florida law or change service requirements. So what can we really do? I know you guys have some questions in here about, what if the person doesn't want to take it, or what if they're refusing to identify themselves? Well, hopefully you guys have, and yes, I have a question in the inbox about electronic service of subpoenas. That's as well. That applies. There is no provision to serve process electronically. You can do it and they might send you the records, but if something gets lost or they refuse to provide, well, you don't really have an affidavit to fall back on. So what can we really do? The internet is our friend. You guys are our friends. You guys know your client who is suing most of the time the person we're serving the documents to. If they have a photo or a description or vehicle tags, that stuff helps. We can also run skip traces. Skip traces give us places of employment, most recent vehicle registrations, driver's license information, property ownership. So that running a skip trace for a person who's avoiding service is my number one go-to. Calls. Sometimes people cannot be found and you can just give them a call and they'll answer and they'll say, oh, I didn't realize you were trying to serve me. I'm at this address now. So as a last resort, I always recommend making calls to the defendant. Now, if they're avoiding service, obviously that's not going to work. Wait time. This is what works when people are avoiding service. What we do is we'll have a process server on the house real early, depending on what type of job the defendant may have. We can catch them leaving the house or coming back from work, put a process server on the house for some wait time and catch them leaving. Missed delivery notices. If it's not a very adversarial action or if we know the person's not avoiding service, they might have a random job such as a trucker. Process servers can leave missed delivery notices, not exactly saying you, Diane, are being sued, but some type of notice that they're missing a delivery where they give you a call and contact to coordinate service. Whenever you can't serve someone, I get asked all the time for affidavits of diligent search. This is where we make the phone calls, run the skip trace, try to serve them at every address, so on and so on. We basically provide an affidavit for the court, and in some instances, it allows you to proceed with methods of alternative service methods or service by publication. And sometimes we can just drop it and wait, right? Because all service is valid until it's not. So if your process server just leaves the documents on the floor and the person comes home and sees that paper and sees that they have to file a response in 20 days and they lawyer up and the lawyer files a waiver and they file an answer, well, the courts have jurisdiction now and that service is good. But should they try to quash service or you collect a judgment, they're going to have the grounds because just leaving the papers on the floor with no one is not valid service. There is nothing called drop service in the state of Florida, right? The attorney said just drop serve him. There is no such thing. What we do have, and hopefully this will answer some of you guys' burning question in the chat box, what we have for when someone is avoiding service. In Haney versus Olin Corp., a sheriff arrived to serve an individual, Mr. and Mrs. Haney. They were outside. The sheriff came outside, informed them of the contents, tried to serve them. They ran inside screaming, no, 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 slammed the door shut, refused to open the door. The process server identified himself. He read the contents of the documents, and he left them in a secure and visible location at the door. Courts ruled this is valid service. The defendant cannot play, I didn't touch it, so I never got served. If you identify the person, so if I'm serving Diana and I have a photo of Diana, or I was able to go on Facebook and find a photo of Diana, or if when I asked the person I'm serving who's Diana, if she is Diana and she confirmed, well, now I've identified her. And if she doesn't want to take the paperwork, I'm leaving it at her feet or the door or next to the car, because there's nothing in the Florida statute that says she has to physically accept it from me. If she slams the door shut and drives off, I leave it on the floor. Okay, that's her problem. Tips for success. This is, what I see as a business owner, some stuff that I would recommend other paralegals do. If you're serving a business entity, any kind of entity, whether it be a corporation, limited liability company, partnership, DBA, always go on Sunbiz and check their most current filings. I think the filings were due a couple months ago, but they're still coming in. So I'm seeing updated filings. You never know who the registered agent is. They may be different by the time you've filed your documents and the summons has been issued. Always check your documents when you're sending them. A lot of times we see summons with complaints, but no stamp on the clerk from the clerk, or we'll see the summons, but no complaint. Not every process server knows to check the documents. So either make sure you guys are checking the documents or that you're working with someone who is. Combine the documents into one PDF. So all the time, I've got a couple law firms that send me one service package for one defendant, but there will be 14 files or 15 files. We're okay with combining them and putting them together, but ask yourself, what if we make a mistake? Or what if you make a mistake and don't check, omit something or include duplicate copies of something? So I would recommend combining your file into one PDF and going down the list, making sure your summons is issued and you have all the documents you need. File size. I get this all the time. Kevin, why haven't you responded to my emails? I sent you the job 3 days ago. Well, when we go to look, the document's file size is over 25 megabytes. And unless you're putting them in a Dropbox link or a share file, we're not getting that file. Reference numbers. I've noticed a lot of law firms, larger law firms, have reference numbers for their cases. This is awesome. It makes things easier for us to look up everything you need on your case and make sure everything is combined. Routine, rush, or any special instructions. Make sure when you guys send documents to your process server, you set the expectations with them. Do you need it served next week or do you need it served within the next hour? They don't know unless you tell them. Family law, very important for family law that you guys let your process server know if the opposing parties reside together, okay? Foreclosure landlord-tenant law. Typically you're serving for your client, right? The plaintiff is your client and the plaintiff is the homeowner. They should know if it's a gated community and if the process server requires a gate code to obtain entry. Yes, we didn't have the statute up, but process servers, it's in the Florida Statute 48, we are granted unannounced entry into the gated community, but that only works if the gated community has a security guard, okay? So if there's no security guard, the only thing we're limited to is calling someone or following behind someone, which can sometimes be tough because of the double gated communities and the arm bars. So if there's a gate, include that gate code. And just set the expectations. Anytime you work with someone, make sure you guys are on the same page. Communication is key in any relationship. And with that, I'm going to run through some questions I have in the chat box here. Bear with me just a moment. All right, so first question. For Florida service that will be taken, I'm sorry, I already answered that one. The second question is, what is required of the process server to verify if the person served is the correct person? So we don't know what we don't know unless we provide a photo or a description or that person identifies themselves. Bear with me, guys, just a second. The Q&A on the other side, I didn't have a mouse scroller. Are you allowed to serve on Sundays? You saw it in the statute, no service on Sundays without a court order. I've never seen it in 13 years. I've heard about it. Why is email service no longer valid? We send email service once the person states they will accept service via email. Excellent question. Not email service, it's not that it's no longer valid, it's that it was never valid. You emailed the documents to him and he filed the response, meaning the court obtained jurisdiction, and you got, or he filed the waiver of service, right? Attorneys typically answer these waivers and they submit themselves to the jurisdiction of the court. Once you have that, you're good to go, right? All service, remember my second slide with the hair dog, all service is valid until questioned, okay? What is the federal or Florida statute on motion and order on appointments? I understand it is county dependent, and how does this vary with subpoenas? Excellent question. Subpoenas, unless it's a criminal subpoena, and how do I know it's a criminal witness subpoena? Because the plaintiff is always the state of Florida. We saw in the statute, criminal witness subpoenas require service by a person authorized. So if you're sending criminal witness subpoenas to Volusia County, they better have a motion and order because there is no licensing program in that area. When it comes to the motion and order, this is probably the number one question I get. The motion and order is needed when the service of process is taking place in a county that has no licensing program. It doesn't matter where the case is filed, it matters where the service is taking place. And we'll send you guys a template motion and order and the list of the counties so you have them. But if you're sending a summons or a criminal witness subpoena, and again, this is a state court summons to a county like Volusia, you have to do a motion and order to appoint. Federal documents do not require motion and order appointment. I left it out of the statute. Those can be served by anyone 18 plus. This is a great question. If a defendant is served out of state, does the return of service have to comply with Florida statutes? Absolutely. Think about it this way. Who's taking jurisdiction over that defendant? It's going to be the Florida state court. If you send it to California and you don't tell your guy not to serve on Sunday and he serves it on Sunday, that defendant can file a motion to quash service because it's not compliant with the Florida state statutes. Question in the inbox says, how do you know if the person who answers the door is 16 years of age or older? Excellent question. In Florida, the co-resident statute says 15. So I can substitute serve a co-resident 15 years of age or older. How do I know? I have to ask. Do I ask them, are they 15? No way. I'll ask them if they're 18 and they'll typically tell me they're 16 or 17, at which point I have confirmed their age. Oh, and I see that, yep, 15 years. Is a process server allowed to wear a camera on his or her person if they expect a person to refuse service? So I cannot talk about body cams, but the sheriff does not authorize us to wear body cams as a process server. I wouldn't want to wear a body cam when I'm knocking on someone's door as a process server anyway, because when they open that door, I never know what's on the other side, right? There could be children running around without clothes on, all sorts of things. But people have a right to privacy in their home. I'm not recording what's going on inside their house. I typically recommend people getting dash cams and tilting them towards the front door so you can see what happens. And again, the question was if they refuse service. If they don't have to accept service, right? If they refuse it, I can leave it at their floor. Haney Versolin Corp says you cannot avoid service by physically refusing to accept it, right? Speaking of avoiding service, question, and I'm going to speed it up a little bit because I see I'm running out of time. What if the person refuses to answer their door or has a locked gate? Well, if they refuse to open the door, there's nothing in the statute that says they have to open the door, right? Again, Haney Versolin Corp, the door was closed when the process server left the process. So if they, if they look out the window or if they tell you from the inside that they're home, you can leave it at the door. It's very difficult for process servers to get past the log gate, right? That's when I recommend wait time and waiting for someone to come in or come out. Question, our process server was unable to perfect service and had direct knowledge to Sunbiz corporations for process online. Are you able to explain how service through Sunbiz works when personal service has failed? I'm not sure what the exact question is, but there is no provision in Chapter 48 that we learned about service through Sunbiz. Perhaps your process server went on SumBiz and found another address or found the home address of one of those officers and served that officer at home. How would you obtain service on an active duty military member stationed overseas on deployment for a civil matter? Oof, that's a tough one. We've dealt with overseas service. Anytime you serve someone overseas, you have to comply with the Hague Statutes. Now, I've personally, in my 13 years, have never served someone at a military base internationally. We do serve on military bases all over the United States. Sometimes they're different. Everyone is different. Sometimes they have their own court liaison that you can send the documents to that will get the documents to the defendant. Sometimes you have to coordinate with the defendant's superior officer. They're all different. Sometimes you might not be able to get service. Remember, this is a civil case. It doesn't meet criteria for service via alternative means, aka doing that affidavit of diligent search and doing service of process by publication. Ooh, this is a great one. Are you required to have an alias summons issued if you have an alternative address, or is it valid for the server to scratch out the address and handwrite it on the return of service? Okay, here's some short answers. You are not required to get an alias summons. The process server can serve that original summons as long as it hasn't expired, right? And when does process expire? 120 days after you file the complaint. They can serve that original summons at a second, third, doesn't matter where. What they're not going to do is they are not going to scratch out and handwrite the address on that summons. What they're going to do is put the proper address of service on the return of service, okay? How do you actually serve someone in jail? I serve Orange County Jail. I send my wife to serve in Orange County Jail all the time. You show up, you provide them with your license, you show them the paperwork, they'll give you a visitor's badge. Typically, the paperwork cannot have a staple in it. They're going to check through it, right? And other than that, I go right through the jail and serve the inmate. Let's see here. How does this work with P.O. boxes? Unfortunately, it does not. I don't believe I put the statute in here about how to serve someone who has a private mailbox or virtual office. There is a provision in the Florida statute for you to serve these types of at these places, right? Whether it be a UPS store or a Regis virtual office or a WeWork, whatever it is, if that's the only address available via public records, you can obtain service on a private mailbox, virtual office, executive office, or mini suite. However, that statute does not apply to P.O. boxes, okay? Let's see here. Is a gated community required to allow a process server access to the community? It darn skippy is. I have to ride around with it. It's chapter 48.031, subsection 7. I have it printed out because if there's a new security guard, he doesn't know the rules typically, and I have to show them that he has to allow me unannounced entry, okay? How about serving someone at a hospital? If they will allow me entry up to the patient, you can absolutely do it. However, most of these hospitals will not allow you to serve a patient who's at the hospital. Question, I have treating physicians who do not want to be process served but for depositions and rather get their subpoena by email. So they accept service in writing through email. Yes, that's great. And when they show up, awesome. You saved yourself the $45 it costs to serve them. However, what happens if they don't show up? Or what happens if something happens and if they don't show up, you cannot hold them in contempt of court. Let's see some other good questions here. Florida Chief Financial Officer for service on insurance carriers is now requiring service via upload to their portal only. Yes. Can you believe it that the Florida Chief Financial Officer is violating the Florida statutes? Okay. When we send it up to Tallahassee, we still bring it to the actual CFO because otherwise, what happens if it gets lost or if they don't file an answer? Yeah, someone asked me if my case law was still valid since 1971. that case law still stands. We provide that case law in the 16 and 4-hour renewal process server course, because these are the good ones, right? The Haney Versolin Corp. When the people refuse to accept service in hand, what can we do? We can leave it on the floor. Dan, I think I'm coming to an end. Do you want me to keep going down the questions?
Nope. If you're done, that's great. And we greatly appreciate you. And thank you all for attending today's webinar. The course number, I know several of you have been asking in the chat here, is 9331. Again, the course number is 9331. This webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general CLE credit and 1 hour of ethics. Please self-report this course in the member portal. You will receive an email tomorrow via Zoom outlining this information along with the materials that Kevin talked about. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is completely confidential and free of service, which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.